This is The Law Matters. Of course it does. Welcome once again. Hi, I'm Debbie Morais, your host and moderator. As we tell you, this long-running program continues to provide legal information, relevant examples, and practical assistance to help you with law matters. A better understanding of the law puts you in a better position to decide how to protect yourself, your family, and your business. As we continue to present various topics, you, of course, may decide to handle some issues yourself. If you decide to enlist outside professional counsel, our hope is to have you better prepared and be in a position to better prepare and work with your counsel. Our goal, as always, is to help you achieve the best results while saving time and money. Again, we want to welcome attorney David Bazar from the Bazar and Associates law firm in East Providence, who continues to weigh in on the topics we discuss. And together, David and I would like to welcome our guest today, attorney Harris Weiner, from East Providence-based Harris Weiner law firm. Harris concentrates his practice in commercial litigation, including contract, real estate, intellectual property, employment, probate, and financial disputes. He works with small businesses, individuals, public agencies, and banks, and Mr. Weiner also advises corporations, LLCs, partnerships on risk management and governance while negotiating leases and contracts, and enforces trademarks and copyrights, which sets us up for today's topic, which is non-compete agreements, often called the scourge of employees, but are they? What are they and how do they affect you? And on the other side, how do they protect the employer who invested in training or in trade secrets or in developing a valued sales staff or client list? What can you, on either side of the fence, do about them? There are loopholes, there are consequences, there are difficulties in defending them. What are those things about? So we are talking about those things today because it's a hotly contested federal issue. Interesting points. Here are some of the reasons we're going to discuss it today. The Federal Trade Commission proposed a rule that would ban companies from requiring workers to sign non-compete clauses. Apparently, approximately 30 million workers are bound by these agreements, which are meant to protect the investments that companies have put into their businesses and their employees, which is understandable. Without non-competes, it's said that wages could rise by nearly $300 billion a year. Interesting. So this is not any longer just about techies with trade secrets and highly paid executives. It's also affecting hairdressers. In other words, white collar, blue collar. Many of us. So while it's nice to advance your career, there might be some issues with it. So let's talk about that. And let me toss this ball to you first, Harris. Could you give us an overview about what a non-compete clause is?
When a business has a legitimate interest in protecting its confidential or proprietary information, it's appropriate to restrict future employees from disseminating that information, or from using it immediately to work for a competitor. And trade secrets are the classic example. A trade secret is a non-public piece of information. It could be a formula, it could be a strategy, a marketing plan, it could be a customer list, so long as those customers are not publicly known. And what you have to distinguish is the non-compete, which traditionally limits the mobility of an employee to go to a competitor, from a non-disclosure agreement, which is often grafted on to the non-compete. So a new employee comes to a company and they're asked to sign a document, and there may be a non-competition provision saying you can't go immediately to a competitor in this market, in this industry. That's the classic non-competition agreement. But also, those agreements tend to have a non-disclosure agreement about trade secrets, and that is perpetual. That doesn't expire. There could also be a non-solicitation provision saying you can't solicit our customers for a period of time. And another one is you can't solicit our employees to come work for a competitor. So there are a lot of aspects that are related to non-compete agreements.
And all of these are being challenged with this, or what part of it in particular?
Well, the black letter law is a non-competition agreement has to be narrowly tailored for legitimate purposes.
Good to know.
So if you can protect your business with one of those other devices, a court may look unfavorably on your agreement. Courts are divided across the country. California has never enforced employee non-competes. Several Midwestern states don't enforce them. That shouldn't be confused with a non-competition agreement when you sell your business. When you sell your business and you say, I won't compete with the new owner for 5 years in this region, that's more likely to be binding, even in California.
The restrictive covenant.
The restriction when you sell your business is different than the one about you leaving to work for a competitor.
Okay, so David, hearing this, and it does seem kind of wide encompassing, if we've told our viewers that there are times when you can do it yourself, with what Harris has just laid out before us, if someone was presented with this kind of a contract that they should sign to non-compete, and they took it to you, would you say this is something someone could easily themselves review, or do they really need to have a lawyer go through this, considering it seems pretty encompassing?
So I'll answer that in two different ways. First of all, usually when you have an employer asking you to sign an agreement, it isn't just the non-compete clause, but there may be several others that Harris has already mentioned.
Yes.
And they are complicated. And so what's the enforceability of them? What's the likelihood that you're going to be bound by some of these things? I always recommend that before you sign the contract, limiting your right to work or do things, perhaps you should speak to an attorney about that. And as the other side of the story is that Harris mentioned about when you sell a business and you do have the agreement not to compete in a certain area and region, as those are more easily enforceable, you should also speak to an attorney about that. And I'll give one quick example. Early on in my practice, I had an attorney come to me that I worked for. I was an associate, he was the partner, and he said, hey, I have a client who's got a problem. Here's the agreement, and this is what happened. So the situation was he owned a Portuguese-American market in Providence, and he sold it. And the agreement he had signed, which we hadn't reviewed and was being brought to us because of an enforcement issue, was it said you can't open another Portuguese-American market within 5 miles for 5 years. And he opened up a year later across the street the American Portuguese market. And so he came because he was being sued and he wanted to know what the problem was. And I said, well, you opened the same type of business across the street within the time frame. I think there's a strong likelihood this will be enforced. And he said, it's not the same business. I sold the Portuguese American market and this is the American Portuguese market. It's totally different. Well, no. If you had spoken to an attorney before you either entered into the agreement or signed that, we might have explained to you what you're really looking at substantively.
It's like semantics. So if someone is presented a contract, keeping as a prospective employee, comes to you and says the employer wants me to sign this, can that, and I'd say this might be something you might want to address too, Harris, could the employer not hire someone or fire someone if they refuse to sign it?
The short answer is yes. It's a condition of employment. You really need to see a lawyer, and Massachusetts requires them to give you time to see a lawyer.
It does.
It does. The Massachusetts law is very different than the Rhode Island law. The Massachusetts law is much more protective of employees than Rhode Island law. There have been legislative developments across the country, but in Rhode Island, for instance, they only prohibit non-competes for minors and low-income earners, because it doesn't make sense to make all your blue-collar workers who don't have access to privileged information to be tied up in their careers. So it's important to know what state you're in, what the rules are. Massachusetts, they're limited to 1 year. In Rhode Island, there's no such limit. I've seen non-competes for 5 years.
Is that reasonable?
It depends on the circumstances. If it is the sale of a business, it could be very reasonable.
Okay.
If it's just an employee in a car salesman or someone in a flexible business model, then that would probably be too long. You've got to look at the agreement and say, all right, what's the duration? Is that unreasonable? Would a court agree to that? What's the location? What's the geography? Because that's critical. Some non-competes are overbroad, and they cover the whole country or the whole world, or they try to cover an entire industry. So the non-compete should really define narrowly what industry, what location. I represented a prominent Rhode Island plumbing business, and they wanted to stop their top salesman from going to Massachusetts. And the judge said, you're in different markets. Even though you have some sales in Massachusetts, you are a Rhode Island company, and he's not competing for the same customers. The other really interesting thing about non-competes, why I like them, is because they are so fact-specific. If the employee is facing a hardship because he's being put on the sideline for 2 or 3 years, the judge can factor that in. If I've broken non-competes where I have a client who can't get a job otherwise, or he's been offered a job by the only competitor in the market, and the judge could make an exception under the hardship rule for that person. And that's one of the best ways to attack a poorly written non-compete. So I've been on both sides, both management and for employees, and I think they're really interesting. And they're among the few contracts that a judge will rewrite, will blue line, and say, I'm going to cut that from 3 years to 1 year. I'm going to cut that from New England to Rhode Island. I'm going to limit that from the entire auto industry to just retail sales. Mm-hmm. And that's very unusual for a judge to engage in.
Insightful. So David, you work in Rhode Island, obviously. What would happen if someone said to you, how can my employer keep me from working within the state or X number of miles? Rhode Island's a small state. It means I'm going to have to uproot my family, go to another Connecticut, I have to go to Massachusetts, or I'll have to suddenly commute for an hour and a half by train or whatever they have to do. Does that seem like something you'd want to take on as, I think we might contest that particular geographic clause?
The geography is actually very interesting, and it's very specific to the type of work that you're doing. I actually represented a client who was a very high position at a pharmaceutical company. And he actually worked in a division that was only mail order drugs to retail clients. And so his agreement was 5 years to a competitor who sold medical prescriptions by mail. And he was offered to be the CEO of a company that sold prescriptions by mail, but only to nursing homes. And it was very different than the job that he had in what that company did, which didn't sell to nursing homes, they sold to retail customers. And so the geography nationwide was actually very reasonable because mail is nationwide, and that's who you were selling to. But we broke it because we were able to show that what the mail was too broad because it wasn't specific to what that other company did or what that other company was contemplating doing. So since it was a different niche, even though it was by mail, we got an agreement that he was able to go to the other job.
Makes sense. You mentioned taking customers from your present employer. There are times when, in certain industries, it takes a long time to cultivate a prospect and make them the client, and that relationship is often critical. Well, if that employee wants to go elsewhere, that client may want to be with that person who left rather than just stay with the services of that previous employer or that company. Is that defensible?
There's a bright line test. If that employee solicits those customers to come to his future business, that's a breach of his employment relationship. That's a breach of fiduciary duty, and a court will throw the book at him.
Okay.
I had a case where a prominent insurance company went into a panic because their lead salesman had solicited a whole block of customers before announcing that he was leaving.
Okay.
And they had already signed some documents transferring their accounts.
Okay.
We were able to disgorge any profits he made from those accounts. We don't have the power, the employer doesn't have the power to force the customers back. That's something to keep in mind. The customers are free to go where they want. And it's okay, if you don't have a non-solicitation provision, to try to sell your former customers at your new company, unless there's something specific in the contract to prohibit that. Mm-hmm. But you can't do it while you're employed. You can set up a new office, you can buy your furniture, you can buy your stationery, you can hire employees, but you can't steal customers while you're there.
So you've done, as you suggested, you've moved into a new place. You haven't even told your employer or the clients with whom you work that you're leaving. Now you leave, and you didn't say anything about come along with me, but they had your cell phone. They call you. You didn't solicit them. How does that play out if the former employer says, you solicited? You say, legitimately, I did not. They sought me out. Is that? How does that
and that's
work?
A common fact pattern.
Yes.
That arises.
I imagine.
Who owns the phone? Is it your old phone that was paid for by your former employer?
Is it that technical?
Yeah, it gets that.
Okay.
That
good to know.
refined. The analysis has to be granular in these circumstances.
How do you think about an employer who deserves to have protection? You talked about trade secrets. He's also taken time to train that employee, bring him along. I mean, he has an investment that needs to be protected. How do you help him reasonably craft a document, an agreement that gives both, they call it consideration, I guess, so that it's fair to both. Yeah. What makes it legitimate? You sort of broached that a little bit at the start of the segment, so could you clarify that a bit for us?
Well, there has to be an exchange of consideration for agreeing to these restrictive covenants. So you're giving something up by agreeing not to disclose, not to compete. So employment is generally considered substantial enough consideration. But if they ask you, once you've started working, they ask you later on to sign one, they really should give you something in return for you giving up your complete freedom and mobility to find another job. There should be a dollar value or a perk, a company car or a better office or different staffing. Most courts will require additional consideration if you ask them to sign after the initial hiring. But the employee can, sort of fight back at the onset. It's more difficult down the road to do that. You're already established at a business.
Yeah, and as Harris is saying, if you're already employed there, past consideration doesn't work. So the fact that you're already employed is not new consideration, and continued employment shouldn't be, you can't condition that on signing this new agreement because you've already been employed. Mm-hmm. So that's why you need new consideration to make it valid.
David, does it seem reasonable to you that if someone is employed and the employer does now present this agreement, that if your client is the employee, maybe some part of it makes sense, but the consideration doesn't seem right? Is that something that's negotiable, you think?
Yeah, absolutely. And
would you suggest, would a lawyer be able to suggest what would be a reasonable
Yep, correct. That's why you're saying one of the reasons you would want to see an attorney, especially in that circumstances, there is grounds for negotiation, and you should have your attorney negotiate that rather than you as the employee trying to negotiate with your employer. It's not as a reasonable situation for you to to assert your rights as it would be for your attorney to do that for you.
And to your earlier question, Deb, you can't undo someone's training. So the employer assumes the risk that someone who he's invested time in and training in may not provide a return on investment. That's the way it goes. And you can use your new know-how in another job, but you can't cross the line into trade secrets.
Software that you developed?
No. If you develop software for a company, that's work for hire, and it belongs to the company. You can't take it with you. David and I grew up down the street from the inventor of G.I. Joe. He invented G.I. Joe while he was at Hasbro. G.I. Joe belongs to Hasbro, even though he was the father of that toy, and it was the most popular toy in America. And he got some recognition, but he didn't own any of the patents. He didn't own any of the trademarks or any of the rights to the toy.
This is a little bit off the mark of the non-compete clause, but related, and let's use the example of a large toy company that you as a prospective employee show your wares to with the hopes of being hired. You're a little guy. This is a big guy. I'm sorry, says the big guy, I don't think we'll be able to hire you, but they saw the goods. They get to come back with an iteration that's pretty close to it. What recourse does the little guy have? Does he have any? How does he prove it? Because you can bet that the large company is going to be saying, our discussions here are going to be confidential. You have to sign off. You're a little guy. You don't have the resources, maybe even the know-how. How would you plan to equip our viewers if they were in that situation? Maybe it's not the toy company, it's any company. But
I had the situation. I had an EMT who developed a neck stabilization device. And he wanted to present it to a manufacturer who was in the same industry. But he said, I want a non-disclosure agreement up front. I want a confidentiality agreement for my presentation and to protect and describe my device. The patent is pending. And if they violated that, he'd have breach of contract. He'd have common law trademark rights in the device. So even without a federal registration, you still can sue for unfair trade practices. In Massachusetts, they have a very strong Unfair and Deceptive Trade Practices Act that might apply. But there is recourse for the small guy.
in view of all of the things you've presented here, before it gets to a court situation, is there discussion of settlement? Is there discussion and negotiation, knowing that this is being contested right now, there's going to be a ban, it's going to have to be retroactive? With all the things that are going on this year, 2023, as we're taping this now, is there reason to consider that it's not likely going to work at the court level where the employer is going to prevail? Loopholes exist. What are your thoughts about it?
Good lawyers do their legal research and try to predict as accurately as possible, based on case law and statutes, where this dispute is going to go, who has the upper hand, what's the likelihood of success. And they should advise their clients whether or not to consider that in settlement. There are many opportunities to settle a case in the life of a dispute, before filing litigation, during litigation, and as we found out in Dominion versus Fox News, even after the jury has been seated. Cases settle even while the jury is deliberating. So over 90% of civil cases settle. So the short answer is yes. Rational business people should be able to reach an accommodation. And you can you can tailor it. You can say, all right, I agree not to compete for a shorter period of time, or I agree not to compete in this narrow segment. My new employer will wall me off from the competing aspects of their business. There are creative ways to forge a settlement agreement.
Sounds good. So, David, we know that this is happening as a discussion at the federal level, and we also know that the states have varied laws. What are your thoughts about this becoming a law as it's stated right now? It's just a proposal. What do you think?
You know, traditionally, these types of contracts are looked at on a state-by-state basis where they're entered into. And whether or not there should be a law that federally preempts it is a legislative issue beyond my control. I've always worked within the parameters of this is controlled by state law, unless there's some other overarching issue.
And Harris,
I think it's very unlikely that the Federal Trade Commission is going to issue a sweeping rule that prohibits non-competes.
So without it being a sweeping rule, what is the latitude? What are the next things that might happen? States will each discuss this individually and where they're going to put the cap geographically if they're in Rhode Island, or is that how that plays out?
Well, as I said, Massachusetts went much further than Rhode Island.
Yes.
Not only do they limit it to 1 year and restrict who can be subject to a non-compete, if you lay someone off who's being sidelined, you've got to pay them during that layoff.
True.
And
Okay.
up to 50% of their salary. So Massachusetts put some teeth into it. They are a high-tech state like California. So in that industry, your knowledge is fleeting. Everything happens very quickly. They want new investment. They always have new companies coming on the market with innovative products. So a year is too long to take someone out of that business. They become stale and irrelevant very quickly.
What happens if you're a hairdresser? You have a client list and you have a low-paying job, or not low-paying, but certainly not on the level of CEO. Should they be nervous these days?
Well, it depends on what their income is.
Okay.
Rhode Island has a clear test based on federal law, and I think that if you're 250% of the poverty rate established by the federal government, you cannot be subject to a non-compete.
Good to know. So for the blue-collar worker, the white-collar worker, we hope that this has been helpful to you in your considerations, and we would like to, together, thank Mr. Weiner for joining us. Please stay tuned to The Law Matters. As we say, it matters to you. Thank you for tuning in.